Right. Good morning, everybody. Thank you, everybody, for signing up and attending. I'm always flattered to see so many of you signed up. So hopefully everybody can hear me and can see the slides. If you can't, if you can't hear me, you can't hear what I'm saying. But pop it in the chat if you're having any difficulties. Brilliant. So costs on the small claims track. Eagle-eyed viewers will have noted that it's yesterday's date on the first slide. Apologies for that. A poor start by anyone's measure. Today is going to be a relatively quick canter through the provisions with some practical tips at the end. And in reality, I think it's more the tips at the end that's probably, probably what you're going to take away from today and what's going to be the more helpful elements of today's talk. So, without further ado, I should say if there's any questions as we go along, please feel free to put them in the Q&A feature of Zoom. I find that this works a little bit better than the chat, just because it's easier to keep track of, and I will do my best to answer them at the end. And if I don't answer them, I will endeavour to get in touch with you afterwards. And yes, this is being recorded and will be available to view at your convenience later on. Costs are irrecoverable on the small claims track. That's what we're all sort of taught, and we keep that with us whenever we think about small claims tracks or whenever we advise clients. Of course, there are little bits of fixed costs recoverable. This talk doesn't go into break those down. They're set out in a prescriptive fashion in the rules, so I don't think we really need to labour that. So today's not about that. It's about trying to go beyond those fixed costs and getting what we'll call unreasonable costs. Another point is that obviously recently there's been the big new introduction to the fixed cost provisions in respect of fast track cases and intermediate fast track and all of that. And there have been and will be talks on that, but we don't delve into that today. And as far as the small claims track goes, there has been no changes in that respect. So whether we're under the old regime or the new regime, the position remains the same in terms of small claims track. So we needn't get bogged down in that. So today basically looks at how we can avoid being stuck with just the small claims track fixed costs and how best to pursue that. So the first one that we're going to talk about is a contractual entitlement. And I should say these are incredibly easy to miss. Usually you'll see these in Section 21 or Section 8 possession proceedings. That's the usual sort of area where there might be a contractual entitlement to costs and it's easy to miss. That's a separate consideration, of course, to standard small claims track trial. But it is fair to say that it's always important to read every last inch of any contract between the parties, whether it be standard terms or conditions, one thing and another, to make sure that there isn't a contractual entitlement, because if there is one, then it may well simplify things a lot for your client. So the position on this, which was confirmed by the Court of Appeal in 2015, is that if you have a contractual entitlement, it does override the fixed cost provisions. As you can imagine, when the small claims track was first sort of established way back when, it was obviously always going to be taken to appeal whether or not you could contract out of those provisions. We're going to see similar litigation in respect of the new fixed costs on the new tracks with the new reforms. That litigation is inevitably going to come, but helpfully for us, that's already been and gone small claims track, and the position is clear. You can contract out of them. Taking that position a little bit further, what about indemnity costs? Well, even when your contract says all reasonable costs, there is authority, albeit the High Court, saying that all reasonable costs can still lead to indemnity costs. So breaking that down, then it's not the position that you, just because you agree to all reasonable costs, you are precluding yourself from ever going above that to indemnity costs. You can still push home on that point should you have a contractual entitlement. So we slightly leave that behind now, but always keep that in mind. And I should also say, when you come to consider this, at this point, that over the years there have been several attacks on this idea through the Unfair Contract Terms Act, referencing different consumer regulations, one thing and another. But as far as I can see from the authorities, nothing has really stuck. So contractual entitlement is still a good avenue to explore. The next one that we're going to consider, which is really the bulk of today, is the provision in the CPR to allow you to escape fixed costs, and that's in 2742G, which is set out on the slide there. And it's really subparagraph G that's the important bit, and it's order to be paid by a party who has behaved unreasonably. So that is the very basis of where we are with this. I should also say that when addressing a judge on this, if you want to make the judge really comfortable with the fact that they can depart from fixed costs, you can also say, well, look, under CPR 44, you still have a broad discretion, and that's right. Whenever one in a small claims track is trying to sort of limit a judge's discretion on costs, it really is difficult because they do have that discretion. But I prefer to focus on 27.4 rather than CPR 44 because this is specific. It actually goes to the point exactly rather than just arguing a broad discretion. So my take on it is that really when arguing for costs on the small claims track, this is the provision to focus in on. So what does it mean to behave unreasonably in this context? And I should say that the commentary in the White Book on this topic is really helpful. So give that a read in full. That would be my advice. Obviously, it's a bit of a lengthy exercise, but the commentary is really good and there are some really helpful authorities. But the main one to focus on is the decision in Danneman, which says basically we can take guidance from the wasted costs jurisdiction of the 468, and from that we get to the real crux of this is, does the conduct complained of, it should say, permit reasonable explanation? So what you are saying to the other side is, what you are saying to the judge is, the conduct of the other side has no reasonable explanation for it. And that is the acid test that a judge should apply. So now we've identified that should be the question that everything flows from. So all of the preparation to try and get costs, all of the consideration should all be based off that question that I've put in bold there. So we will deal with that in more specifics in a moment. But firstly, I'd like to point out a few examples which really, from my experience, often fall on deaf ears and really aren't ever going to be your strongest point. So there's only two of them, helpfully, but I thought I'd spell those out at this stage so that, again, from the outset, you can have clear in your mind what is and what it isn't going to be likely to be taken as unreasonable behaviour. So, an optimistic claim, and we've all drafted them, we've all pursued them, and indeed we've all defended them. That's not going to be enough. The quote there is from the case of Danneman, and it reads, "Conduct cannot be described as unreasonable simply because it leads in the event to an unsuccessful result, or because other more cautious legal representatives would have acted differently." So we have it there. It may well be the case that you looked at things and said, it's the classic thing to say, oh, well, if this was my client, I'd have told them not to issue. We all say when we're defending more speculative claims, but that in and of itself is not enough to convince a judge they've been unreasonable. So the way I think about it, and indeed the way I've made notes on it, is that even if you think you have a 90% chance of success, or even a 95% chance, if that 10 or 5% is still a credible point, then unfortunately I do not think that a judge is likely to go with that. And dividing that even further, if it's a question of fact, which is the likelihood, your chances of convincing a judge are even slimmer, because what the other side will say is, we needed live evidence on this point, and only after live evidence with the prospects of success truly demonstrated, and that point will always resonate highly with a judge hearing a small claims trial because much of small claims trials are based on live evidence. So when it is a case of live evidence, you say squarely, when you say the evidence is squarely against the other side, if they can point to one point, which has always been there and present, that if it goes their way, they could be successful, they will be able to argue that it does permit a reasonable explanation. So again, going back to the question, why did you issue when the odds were against you? Well, we considered that we had a chance of success if this finding of fact was in our favour. And that is, on the face of it, a reasonable explanation. So that's if it's an evidential point that they're optimistic on. But what about if it's a point of law and that they're optimistic on, either whether it be limitation or the construction of a contract, one thing and another? And again, in my view, that always holds more weight than a matter of live evidence, because it is possible for lawyers to go away, consider the authorities, and really come to a reasoned judgment as to which side of the law they fall on. But again, it really does have to be there really does have to be some damning authorities out there on the point that you're pursuing in order for it to really be unreasonable. So again, if they can point to an authority or two that if interpreted in this way supports their case, on the face of it, that is a reasonable explanation. And the second point is rejecting an offer. This is set out explicitly in the commentary in the White Book, 27.14.4, and we needn't really go into that detail anymore, simply to say that that particular quote from the CPR will be wheeled out by any advocate who finds their client under criticism for not accepting an offer when the court has been invited to award costs under 27.14.2G. So do not expect anything like the consequences of that 36 offer to bite in a small claims track, even when you make a very good offer that they fail to beat at trial. Just don't expect it to happen. But that said, it may well be the case that the offer was so good and so reasonable to the point you almost offer to settle the claim and they don't accept, that a judge may be convinced. For example, an example I dreamed up, for example, if they were claiming £10,000 but also claimed interest at an unexplained rate of 12%, and you make an offer to pay £10,000, say we're not paying any interest. In those circumstances, a judge may say, well, hold on, the claim for interest was always shaky. It does not permit reasonable explanation to reject that offer. So I'm not saying for a moment that rejection of an offer will never lead to unreasonable costs. That's not what I'm saying. What I'm saying is that this example, along with a speculative claim, don't simply see those points as being excellent points to run for unreasonable costs. If we were discussing potentially indemnity costs or another point like that, the discussion may be different. But here we really are constricted by the rules and the authority of damnation. So again, it's a cautionary note not to place too much weight on that. So, Harry, what will ever be enough? And I've just put the word, as you can see, discretion there, because that really is the point to emphasise that this will always come down to a judge and their view on the case. And I should also say, and it's important to highlight here, that what we have is a friction between policies. We have the policy of on the small claims track, litigants do not recover costs. And there's a whole policy behind that, litigants are supposed to do it themselves, etc., against this idea that, well, there needs to be some onus on the parties to behave reasonably. And this is a conflict between policies, and some judges are more wedded to the idea that small claims track should never really be costs awarded, and others are more inclined to be flexible. It's easy to identify that when a judge considers these points, there is clearly that conflict in policies that they're thinking about, and some judges will naturally fall down heavier on one side than the other. So there will always be a discretion on the judge. So when the question, what will ever be enough, it really does depend, but it goes back to that question, does it permit reasonable explanation? And that is always going to be fact sensitive. It's always going to be really case sensitive, and often it's not going to be very obvious, which comes on now to the second part of this presentation, really, where we talk about what we can do to really bolster our chances. So what can we do? And the answer in short is more than this. These are snippets from, albeit I've made them up, but they are perfectly reflective of the sort of instructions we might get. And it's where we're instructed. So counsel is further instructed to seek unreasonable costs due to the conduct of the claimant. Second one, instructed solicitors are aware of fixed cost provisions, but counsel is invited to use his best endeavours to recover costs on behalf of the defendant. Now, often it's the case that, where in solicitors' practice, you go to your client and explain you can't get the costs back, and they say, well, they've done this, that, and the other, and you advise them that there are methods of doing so, and of course, then they want to tell counsel or their representative to go and try and do that, which is all very well and good, but we need to do more than simply say this. We need to take several steps to put everybody in the best position. And I should say, when you get these instructions, there are often some correspondence attached, an email maybe attached to another email saying, look, where there's been one example of correspondence which didn't quite go favourably one way, didn't make one party look particularly good, but we really need to do more. So why? What exactly does not permit reasonable explanation, and why doesn't it permit reasonable explanation? We all need to get that question, answers to those questions clear in our head. So whether or not you are arguing the case yourself at trial, or you're instructing counsel, you need to be able to answer those questions in terms. You need to answer it specifically. So you need to tell counsel, or you need to be able to tell the judge yourself why you should get those costs. And the only way you can really do that is answering those two questions. So there'd been nothing wrong when drafting instructions to counsel, writing those questions out and writing the answer in brief terms. Counsel, frankly, would absolutely love that, because it makes their job a lot easier. And on that note, it's often the case, especially when dealing with litigants in person, that the unreasonable conduct will be weaved into some pre-action correspondence and how they handle themselves throughout the matter. And that's something that's often an ongoing matter, and it's often really difficult for somebody picking up the file, say a week before the trial, to really grasp that and to get an idea of that. And the person who is best placed to identify that and put it in a real concise account is the file handler, is the PN actually managing the file, because they can put it together. They can explain, firstly, what they say was unreasonable. Secondly, they can say why it was unreasonable. And thirdly, which we'll get on to, they can actually say what costs it drove up and what costs were incurred as a result. Because at the end of all this, to take some of my thunder from later on, we have to put some, pounds and pence at the side of all of this and actually point to what costs have been incurred. So, first point, be precise in your instructions, and all this will ever do is free up your advocate's time to properly argue the point. So rather than looking for the evidence and the justification for the argument to start with, they will be able to focus on the authorities and really putting it all together in a concise argument. So, evidence. Ensure where possible, obviously with offers and whatnot, that won't be possible, but ensure the trial bundle has the relevant correspondence. If that's not possible, or there's too much of it, consider a supplemental bundle, which can be handed up after judgment has been given. And even if we feel really strongly about it and it's a point that needs some sort of fleshing out, consider preparing a short witness statement. In doing this, what we're doing is making it easy for the judge, because at the end of a small claims trial, the judge probably won't have a lot of time, and we need to get through these points quickly and make it really accessible for the judge. So what I'm talking about, let's work through an example. If it is the case that somebody has run a trial purely speculatively based on an evidential point, but we say, well, we have 3 independent witnesses that all say something different, you're not going to be successful we need to put before a judge an email or a letter, and ideally confirmation that it's been received, saying, we have these three witnesses, here are their witness statements. You are not going to be believed in the face of three independent witnesses. And then at the end of the trial, I can show that to the judge and say, look, this was explained back in February, and he or she, they have carried on with the claim unreasonably. That's one example. Secondly, if it's an offer that's been refused, again, we talked earlier how that isn't the strongest point, but if you put in correspondence, for example, to a litigant in person, spelling out the law on the point, if you've attached the relevant, or statute or even authority and sent that to them and say, look, this is the position, take independent legal advice, you put yourself in a much better position, frankly. Or the textbook example is where a very common example is where a litigant person sues the wrong entity, the wrong party. For example, they consider their contract was personally with the managing director, but actually all the evidence points to the fact it's with the company. Write them a thorough letter attaching how the invoice always went to the limited company, how the pro forma was signed in the name of the limited company, etc., etc. Really put it in brief terms to the litigant, and then evidence it to the judge. So show the judge exactly what conduct is unreasonable. Or if there are more contentious points where parties do not respond to correspondence, or they outright refuse to to reasonably cooperate, for example, agreeing a bundle or insisting on other correspondence going in, or insisting on offers going in the bundle, attach that correspondence in a supplementary bundle so it can be shown to the judge and we can point to unreasonable conduct. In terms of the witness statement, obviously that's more work, it's more cost for the client, so one has to take a view. But if it's the case that it's all, for a lot of it's been over telephone calls, that might be the only option. But I think that the point here, as I sort of ramble on, is if we're serious about pursuing unreasonable costs, and really do put some thought into what evidence we can properly put before the court. And usually that's even a trial bundle or a supplemental bundle. So don't leave it to counsel to say, well, I have an email here from so-and-so date and I can read it out for the court. Let's go a step further. If you have the time, and if you're able to send counsel 3 or 4 email attachments, throw them into a PDF, bob a covering page on it saying supplemental bundle, and have counsel print it off and take it to the hearing. It's perhaps another 10 minutes work at that, and it will put you in a fantastic position. So do that. That would be my advice. The next one is additional points. So, and these are points that also have general application, but if we're going for reasonable costs, ensure that the schedule is served and filed in time. And in terms of service, give your representative or whoever's going on for the hearing evidence that it's been served. So give them a copy of the email, give them a copy of the covering letter that's saying sent by first class recorded delivery or one thing and another. Really make sure they have that evidence, because a real easy way for a judge who is on the fence about this to not award costs is just to say, well, I'm not satisfied that the party has had the cost schedule. They haven't had a chance to consider it, and therefore I'm not going to carry out a summary assessment. It's a really easy way that you can fall down. You can do all the extra evidence. You can give full and proper instructions to counsel, all of which costing your client money. But you can fall down to the very end by not having served and filed cost schedule. And again, that's of general application, so it's not incredibly particular to this pocket of litigation, but it's important nonetheless. Second one is put the other side on notice of pursuing these costs. Earlier the better, and reference the relevant conduct. There's nothing, as far as I'm aware, solid in the rules saying you have to do this. There's no, as an on-notice or sort of without notice application, anything of that nature. But again, it's down to the judge looking at the fairness of it, especially when you have a litigating person. If you put them on proper notice in advance, it just makes the judge feel that bit more comfortable. And in fairness, taking an objective view, the more notice you give people, especially to in person, the fairer it is. So I would recommend that as well. And the last point is be specific. So what we don't have to do is always pursue all of the costs. Okay, we don't have to put in a schedule that says everything from your first telephone conversation with the client to any conferences with counsel, drafting everything, one thing or another. We don't have to do that. We may well want to do, and the conduct may be that bad to justify it. But if we stop and think for a moment, is a judge more likely to award some specific costs or just a broad brush the whole case? And obviously, it's the former rather than the latter. So be very specific. If it's the case that the conduct of the other side has caused you to, for example, wade through hours of disclosure, put that in terms in a cost schedule. If it's the case that they have refused to play ball with the bundle, and even as a defendant, you've had to put in your own bundle and consider the contents of their ridiculously large bundle, put that in the schedule, explain where you're coming from with those costs. It's not the case that you have to get all the costs. And again, back to the offer point, if this was Part 36 offers, of course, we have split schedules. You have different cost consideration for different periods. Well, there's nothing wrong with doing that in these cases. If you put in a fantastic offer 3 months before trial, do a schedule of costs that were incurred after that date or after 21 days after that date if you want to have parity with the Part 36 provisions. Do that. And so what this will do is when you have a judge on the fence, it makes them a lot more inclined, make them a lot more comfortable in awarding costs which they ordinarily wouldn't. And it's saying to the judge, look, we're taking this seriously. We are not simply demanding all of our costs because of some loose reference to correspondence. We're pointing to very specific things that we can actually show do not permit reasonable explanation and have actually caused these costs. So again, you're making it very easy for the judge to make the decision. So those are the points I have to make. In closing, what I would say is that always advise. My advice would be always, when advising clients and giving indications of the likelihood, is say to your clients, look, this will always be speculative. This will always be a bit of a shot in the dark, and you might have to spend a tiny bit more on our time and perhaps counsel's time in arguing it, but there may well be prospects. So if you're advising those terms, you should always have you shouldn't have an unhappy client if it doesn't go our way. So those are the points. I'll take a moment to, I've had, thank you very much everyone for some questions. I'll take a look at them now. So the first one is non-compliance of the pre-action protocol assisting the recovery of costs. For example, defendant refuses to engage in correspondence, but suddenly submits a defence which they subsequently lose on. It perhaps could have been a freestanding third example of points that don't often, in my experience, really get any traction. But non-compliance with pre-action protocols, in my view, aren't really going to be enough. But as you put in the question, if it really comes to something, then possibly. I think that example where they eventually lose isn't the best, perhaps the strongest one. If they don't engage in pre-action correspondence and then they put in a defence which, perhaps blows your claim out of the window. For example, if you're claiming against a landowner for some work done on the property, and they say, oh no, actually we sold the property, it just hasn't gone through yet. You actually should be claiming against the next person, and they put that in a defence, but they didn't tell you before. Then you may have grounds to say, well, non-compliance with pre-action protocol, this is why we have it, and we should get our costs. So I think yes and no is the answer to that question. The next one, the webinar on the new fixed cost regime from October. Yes, I think that has potentially even already happened. If it has, it will be on the King's Chamber's website or YouTube channel. But if not, it will certainly be coming up. I know Andrew Hogan was heading up that talk. A question from Mr. Richard Bennett. So optimistic claim is not unreasonable behaviour. What is the situation where the defence has no prospects of success? It's very much the same situation, but in reverse. If you can demonstrate to the point that defending it did not permit reasonable explanation, and then possibly. But again, if there's any element of it that's perhaps speculative and that it does have some prospects of success, potentially, it really is fact specific. But I think it's fair to say that it really will have to be a properly deficient defence, or really without any basis to get that to get those costs. And that argument will always be stronger when you have brought a strikeout or summary judgment application than if you let it run to trial. That's what a judge will always say. And I think it's a really unfair thing to say in the context of small claims trial with the costs. The judge will say, well, if you felt that strongly, why have you let it run to trial? And obviously your clients say, well, the costs of the summary judgment strikeout application weren't that far off from a trial, so it was more efficient just to do both at once. But a judge will throw that back at you, I'm afraid. So yes, I hope that answers the question. So in terms of I mentioned the different cost schedules, would you recommend filing a full cost schedule and then a separate one which specifically deals with the time spent dealing with the unreasonable conduct, which shows the clear divide? Yes, I think a judge would find that very helpful. So if you can demonstrate to the judge, these are the full costs, these are the costs that we say are caused by unreasonable conduct. And firstly, you give the judge the option to award the full costs, but secondly, you demonstrate in context how significant the extra costs are. And again, if you do that, you're showing the judge that you're taking this even more seriously and properly putting some time into it. So I think in the right circumstances, that would be a good tactic. Does the fact you have dealt with the matter in-house make it harder to recover small claims costs? I'm not aware of any solid authority on the point, but the reality is I think judges will always be more against you just because you can't say, essentially, look at my poor client, they've incurred these costs with the firm of solicitors. It will be a lot easier for the judge to say, well, you have provision in-house to deal with claims, you haven't had such a substantive loss. Again, it's an unsatisfactory answer from me, but but it seems to me that that's likely to be an answer you may get from a judge, which will be equally unsatisfactory. So in answer to that, yes, in-house cost recovery is always a different kettle of fish. And yes, I think it will make it harder, definitely, rather than easier. Housing disrepair claims, how can a claimant side argue unreasonable conduct? Again, it's very fact specific, and at the top of my head, it would go to potentially refusing, being unreasonable when experts are arranged to come around, things like that, or generally it's just the tone of correspondence. But it really would be fact specific, so I can't, off the top of my head, I'm afraid, think of some examples. Brilliant. And the only one, helpfully, it's been pointed out that the new fixed cost regime talk has already been. It was Andrew Hogan and Paul Hughes, and that will be available, I think, on the YouTube channel. But if not, do get in touch with one of the clerks, and they'll happily give you a copy, or at least of the slides, as is the case with this talk. Brilliant. Yes, the slides and recordings will be out on YouTube to answer that. And I think I ought now to draw this to a close. If there's any questions I've missed, there might be some on the chat. I will tidy those up and get in touch with the individuals. But other than that, thank you, everybody, for coming. I'm flattered to have so many in attendance. And any questions, do get in touch. Okay. Thank you very much.